Welcome to the Dispute Resolution Commission's celebration of Conflict Resolution Day 2021. The Dispute Resolution Commission, in conjunction with the AOC Custody Mediation Program and the North Carolina Bar Association's Dispute Resolution Section, are pleased to provide you with a fantastic program today. Redefining the Roaring Twenties, moving into a decade of technological advancements, and what that means for your mediation practice. Please note, if you are a DRC certified mediator, this video will provide you with CME credit. However, you will not receive CLE credit. I am very proud and very happy to introduce today's panelists. Ann Anderson is an attorney mediator and arbitrator who has been mediating since 1993. Ms. Anderson is a past chair of the Dispute Resolution Section and of the Labor and Employment Section of the North Carolina Bar Association. She continues to be an active member of the NCBA. She is a recipient of the NCBA Dispute Resolution Section's Peace Award and the Labor and Employment Law Distinguished Practitioner Award. She is also a former member of the Dispute Resolution Commission. Next, I would like to introduce Angela Gray. Angela Gray is the managing partner of the firm Gray Newell Thomas. Ms. Gray has been featured in Lawyers Weekly and numerous other publications for her outstanding work in the area of employment law. In addition to practicing law, Ms. Gray is a certified mediator. Ms. Gray also works as a mediator and arbitrator on behalf of the American Arbitration Association. Kate Dieter-Meriday focuses on the collaborative nature of mediation and how it offers participants a productive, cost-effective alternative to appearing in court. She is proficient in Spanish and is working toward mastery in order to communicate more effectively with Spanish-speaking mediation participants. Kate is the immediate past chair of the North Carolina Bar Association's Dispute Resolution Section, and she volunteers with numerous organizations. Last but not least, we have David Niblock. Mr. Niblock is a partner with Craig Jenkins Lipford and Walker LLP in Winston-Salem. He became an attorney to help people by providing valuable and necessary services. He has been an active mediator for a number of years in both Superior Court and the Family Financial Program. Mr. Niblock believes mediation provides a wonderful opportunity to help others at a great time of need. The DRC is very grateful to our wonderful panelists today. I am so excited to jump right into the first hour of our program and kick off the conversation with the elephant in the room, remote mediations. This past year provided a great deal of adventure for DRC mediators, as we have had to change not only the way we think about mediation, but we have had to change the way we conduct our mediations. Angela, let's start with you. Can you please talk to us today and tell us about your transition into remote mediations?
Conducting mediations via Zoom and remotely have been very, very good for me. And it's been successful. And I think because the clients are more comfortable in their own space, a lot of the clients are at home. Many of them are not even in their attorney's office. Sometimes there'll be remote mediations where the client is present with their attorney at the attorney's office. And then sometimes it'll just have everyone is just remote. And in either scenario, it's been wonderful for me because I think everyone is more comfortable with being remote. Most folks have access to the internet and they are familiar with the Zoom product. So I have had very little, I have had very few instances where folks had to get educated on how to use the Zoom product. I think maybe if anything, it has been how to join breakout rooms and things of that nature. But, you can kind of walk folks through that process. And so it's not been difficult. But there has been a very easy transition for me and for the individuals I have conducted mediations for. I would also say I've participated as an attorney in remote mediations, and they've been tremendous. I will say I believe they've lasted longer when they're conducted remotely. I think Ken Carlson may have mediated a case for me that we started in the morning at maybe 10 o'clock or so and didn't finish until maybe 7:30, 8 o'clock at night. And vice versa. I mediated a case for him that lasted a long time during the day, but ultimately we had to, reconnect after the initial mediation date. So the mediation seemed to have gone very smoothly for me, and I have very little complaints about my transition. David, I hope your experience has been as easy as mine.
Well, it's interesting because as I listen to you, we have many things in common, but some things that have kind of turned out differently from my perspective. But I would affirm big time that the lawyers here that I have dealt with were wonderful as the executive orders began to fly, as we had to postpone many mediations that were set in the time when we were prohibited from doing live mediations. We all cooperated. I think the overriding, and a lot of the mediations that I do are domestic. So when you, in family law matters, and so Angela, when you mentioned that one that went a long time, that's not long for us. Those have a tendency to go a very long time. But as we looked at scheduling those, I think at first there was a real hope and expectation that it would be very brief and we postpone things and that we would get back to doing them live. And part of that dynamic, I think, is driven by, in those cases, I find it more effective to be able to be with someone in person. And I think many of the lawyers here in the Forsyth, Davidson area felt that way, and that we would hopefully get back to that simply because, as is the case in all mediations, that relational aspect of being able to be with someone, you establish credibility with them, I think is easier live rather than remote. However, so having said that, while we waited a long time, and when it became apparent that we were going to have to deal with the remote mediations in order to comply with the applicable rules and executive orders, there was a willingness to do it. We were able to work through it. We were very careful with how we went about it, and it turned out to be really quite effective. In fact, I think as I sit here, all but maybe one of the Zoom mediations that we had found resolution, which is just a credit and tribute to the great lawyers and willing parties who were involved in it. So, but it was interesting. And we had a big backlog as we waited. I recall that when we finally got back to being able to do live mediations, I think I mediated 11 out of 13 days in a row because we had continued so many during the spring, of 2020, and were unable to do it. So I'm thankful for the process. We actually have continued to do a number of remote, although again, we also have been able to have the consent granted by the parties as is required to be live and in person as we've continued to move forward. So it's been an interesting and challenging dynamic, especially for someone like me that is not IT savvy, but we've managed to pull that off, and I'm just thankful that we've been able to get creative and find ways to help folks.
So, David, let me ask you a quick question. Did you have trouble or any problems with parties and attorneys complying with the safety guidelines when you did in-person mediations?
Say that again, Terry. You broke up on me. I'm sorry.
Sorry. Did you have any problems with attorneys or parties following safety guidelines during the in-person mediation?
Yeah, that's a great question. And of course, folks had different views, and it was a challenge. But no, I think we were able to do that very effectively depending upon the particular guidelines and rules that were in place at that particular time. And again, I know that we're blessed throughout the whole state to have such a number of really good lawyers, but they were always cooperative in helping make sure that things ran like they were supposed to. So I think I would say that folks have done a good job of complying with what they're obligated to comply with.
You know, I wanted to raise this point because David made me think of this when he said that he mostly does domestic family law mediations. Most of the cases that I mediated are employment cases or maybe personal injury. But on the employment cases, you're dealing with people who are often remote. Please. And the parties are often remote. So you may have.
It's off.
I hear it. I hear it too.
Sorry, I'm trying to find the person to mute him. Go on. Okay.
What I was saying is in employment cases, you often have a number of folks involved in the mediation, and they are not usually located in the same place, for example. So you may have an employer who is headquartered in an entirely different state from where the plaintiff is physically located. And then if you also have an insurance carrier involved, that insurance carrier may be, physically located in another state as well. So I may be conducting a mediation where parties involved could be from North Carolina, California, New York, wherever. And so the ability to use remote mediation in that context has been excellent. I think in employment cases, it certainly has given me the feeling that folks are more comfortable with the negotiation aspect because they have not had to pack up and fly across country or drive or spend the money to stay somewhere. And then the plaintiff is oftentimes feels much better to not physically be in the same space as someone who they have perceived to, have done them wrong. So in the employment cases, I have to say, I think even emotionally, it's been better for the parties. And now that we kind of are coming out of this mandate to conduct everything remotely, and as we go back, I guess if you want to use that word, to normal, I think normal might continue to include a good amount of remote mediations.
Agree with that.
Okay. And Kate and Ann, you both jumped straight into remote and did not even pass go or collect $200 with in person. Do you guys want to speak to that for just a moment?
Sure. So my daughter works at a hospital in Boston, and when things were developing, she called me almost hysterically, and she is not a hysterical or an hysterical person, saying, "Mom, you can no longer mediate in person." I'm like, "But I've got this case scheduled. I'm going to go." And she was just insistent that I not. So I called up the lawyers to talk to them about going to remote, and they refused. They said, "No, this one's got to be done in person. We won't do it remotely." So I just said, "Well, I'm not going to mediate the case then. You'll have to find somebody else." Well, at that time, they could not find somebody else to mediate the case. So they came back to me about 2 weeks later and said, "We'll do it remotely." But it was a big learning curve, I think, for them and also for me. And interestingly, when we had the Zoom mediation, at that time, people had some questions about the security of Zoom. I think folks don't have those questions now, but then they did. So how I conducted that mediation was I had the general session together, but then the defendants hung up. I left the plaintiffs on Zoom, but the defendants insisted that I go to another room and call them on the telephone to make sure that their security was covered. So I physically, I had the Zoom in one room, and I honored their instructions and went to another room and picked up the phone and called them so that they couldn't hear. No one could hear, but I mean, they couldn't have anyway because I put folks in breakout rooms. So that was how I transitioned. But I was not comfortable with Zoom to start with. I just never really thought this would work. And so it surprised me that now this is my preference. And I've gone back to just doing Zoom mediations. I'm not doing in person. I've done a handful of in-person mediations during this time period, but I've gone back to Zoom because I, like Angela, have found that parties are comfortable in their own home. They're not worrying about the parking. They're not worrying about being in a big office they're not comfortable with. And it's provided, and I've had people participate who would never have participated. I had a CEO from Hawaii who was able to Zoom in, and if he had to fly to participate, he would have never come to North Carolina for this mediation, but he was on screen throughout, and it just changed the whole dynamics, I think, of the mediation. But I had to learn quickly. Jackie Claire, I know most of you know Jackie. She and I kind of got together at first to try to talk about what are we going to do, how are we going to handle this. And I think she had talked to Kate, and we all kind of worked on learning the technology. And I'm a member of a water aerobics group who has no experience with technology, so I practiced on them. We had a meeting every Thursday morning at a certain time, and I would practice putting them in breakout rooms and signing them on Zoom, and everybody always had a problem. And then now they end up using it for family meetings and other things. So that's how I learned and transitioned. But now I know, Kate, you were kind of in the same boat. You just went right to just doing Zoom and had to learn.
Right. Yes. Some similar threads with the three of you. My brother has been on the front lines. He's a nurse practitioner in the ICU in Philadelphia, and so I got a similar call, and that you similar to the one that you got from your daughter. My brother was intubating 4, 5, 6 people every night, and he really uh, encouraged me to right away pivot. And so some of the similarities, my husband works for ServiceNow, which is an IT company. So he jokes that he's the in-house CIO. So he helped me to get up to speed. One of the things that has been really, really helpful, and I hesitate to even say it now because I feel like it's going to create a problem on my end, but we have these Wi-Fi spreaders, and I have 3 children. My husband and I were both working remote almost for the entire 18-month virtual school going on. So we got these Orbi Wi-Fi spreaders, and I should buy stock in the company because I've told so many people about them. For me, that was huge a huge component because I wanted my connection to always be rock solid so that I was never the problem as the mediator in terms of my connection. So that was one of the things that's been really helpful for me to have smooth and seamless conferences. Like Anne mentioned, I've conducted hundreds of these mediations using Zoom, and my settlement rates have not been impacted. I speak Spanish in a lot of my mediations. I find it's easier without the muffling of the masks, be able to communicate with Zoom. I do have a preference for people to be, if at all possible, be on the video camera. I think it's helpful. I conduct mediations with difficult topics, sometimes cases or sexual assault cases, and I've had no change in terms of the ability to successfully mediate those cases, but I do find it's really helpful to be able to read people's faces, see people's faces, get a sense of how they're feeling, how they're reacting, that sort of thing. I had a mediation somewhat recently where one of the participants was having trouble connecting with her, was very quiet, and her attorney stepped out of the room for a second, and so it's my policy if the attorney's not there to just chat about something that has nothing to do with the case. And I noticed she had a plant behind her, and I said, "Oh, what a beautiful plant." Well, it turns out she was a horticulturalist, and it was a hobby, and she turned her camera, and the whole room was covered in plants, and I couldn't get her to stop talking after that. And it was an interesting element. It illustrated for me that if I had been in person with her, I never would have out of the blue said, do you happen to be a horticulturalist? But since she was in her home environment, I was able to see in the background, and it did allow me to establish that rapport with her. So I'm a big fan, and I like Zoom. I will say, I know we're on WebEx right now. I think Zoom platform is a little bit easier to navigate than the WebEx, but I have been very grateful to have the kind of job that we could continue. And the attorneys I work with and was working with at the beginning of the pandemic were very happy to be able to also pivot and continue on and not have any backlog. So
wonderful. So Anne, you mentioned that you had a concern about confidentiality. So I kind of want to play off of that a little bit. How do you all make, as the mediator, make the parties and the attorneys feel comfortable with confidentiality? And then with that, how well do the breakout rooms work? And what are the parties, what is their feeling with the breakout rooms? Do they feel secure while they're in those rooms? Can you guys speak to that a little bit?
Sure. Well, let me start out with the last question about the breakout rooms, because I I do think the parties feel comfortable with the breakout rooms. And in fact, I start off by telling them when I put them in the breakout rooms, this is your private space. It's actually better than the real life space because nobody can hear you laugh or scream or know anything that's going on. And only I can let someone in your breakout room. So I do think that they feel very comfortable with the breakout room. And I um, Kate, like to have the individual's faces on the screen, but that doesn't always work. Sometimes it's just the attorney and the client will be in one block. Um, but the other thing, I've learned a lot. I mean, we learn a lot as we go through this. I think there's something new that happens every time. Um, I tell people up front, if there's someone in the room with you, it's okay. You just need to let me know because I don't want them hiding someone behind the computer or under the desk or wherever. So I make them feel comfortable knowing that it's okay if somebody's there. We just need to know who it is for reporting on the form. But also, if you had been in person, we would need to know who was there. So that's important. Now, I've sometimes seen people kind of walk through a room and, you might have to just kind of gently ask, so I see, is that your wife there with you or is somebody, your child there? We just need to know who's there. Um, and I've also had folks perhaps more purposefully wanting to sign confidentiality agreements. In my initial discussions or disclosures or contact with the parties, I do tell them that if you want a confidentiality agreement, that you will need to address that separately. And I don't know if that's prompted folks to do that or not, but they then will want one. I have just recently had attorneys actually ask me to sign a confidentiality agreement. And in fact, giving me permission to talk to their experts or someone if the case doesn't settle. And I just refuse to do it. I'm not going to sign a confidentiality agreement. I tell them that I'm covered by the rules, and I just don't think that that's part of my um, requirements. And, most of them aren't even familiar with what the rules are as far as what mediators can and cannot do. And so I send that to them. And if they need that, they'll have to find another mediator to do it, but I'm not going to. So I've talked about a lot of things, Tara, but hopefully that covers what you were asking me about.
Absolutely.
Oh, sorry to interrupt. I have just a couple points to add quickly on that topic. One of the things that I like to do in the opening session when everyone gathers, I like to ask participants, can you see me only, or do you see everybody on your screen? Because sometimes if people are calling in using Zoom on the phone, the way they have their view set up, they might think that they are in a room by themselves with me, and I like to make sure they know exactly who can see them and hear them, and then I help them adjust their view if they want that. So I've kind of adopted that as a protocol. The other thing is the chat function in the breakout rooms. Chat stays in the breakout room. It's private and confidential only within that breakout room. The little pull down tab says everyone. So it can be a little bit confusing. And so that's something I sometimes go over with folks so that they know if there's internal chat, it stays in the breakout room. When we first started the pandemic, besides my 3 kids, I also had my 2 nieces living with me for 4 months because it wasn't safe for them to be with my brother. And so to keep confidentiality for participants, I would utilize headphones so that no one else could hear what was being said during the Zoom mediation, and also so that they couldn't hear the chaos and craziness of 5 kids outside of my office door. And then the last thing that I think is helpful on this issue, on this topic rather, is I find it helpful to sometimes be able to have private conversations with the attorneys. And in person, it can be a little bit awkward. You have to be nuanced. You don't want to walk in and say, Joe Smith, will you step out here? I want to talk to you privately. But with the Zoom mediations, I can send a private message and then pull that person. They can excuse themselves, and I can pull them into the general session or another breakout room, and we can have a discussion. So I've found that dynamic to be really productive to be able to move people around the breakout rooms.
It's almost like you're talking about puzzle pieces. I love it.
Let me add something too quickly, Tara, that I thought about that all of us will be able to relate to, and that is when you have a live mediation and you go from room to room. Sometimes, depending on where you are, when you conduct the mediation, the rooms can be relatively close to one another. They might be, you know, right across the hall from one another, or only separated by one office space. And so when you conduct these mediations remotely, you actually have time yourself as a mediator to just kind of compose yourself once you go out of one room and before you go into the next room. And you can just kind of gather your own thoughts. And so to me, that kind of helps to not show any signs of frustration or any signs of that might give the other party information or a message that you really don't want to convey. And so also in these live mediations, the mediator might get thrown out of everybody's room for some period of time. And you might see the mediator sitting out in the lobby, you know, just waiting to be called in. And that can be kind of awkward, because if you see the mediator sitting out in the lobby waiting to be called in by one or the other party, you might want to go chat with that mediator and start talking about your side of the case in an area that might not be private or whatever. But when you have the Zoom mediation, you just disappear and you don't show up again until you join those folks, you know, in their private room. And that time when you're not in their room, they really can't see your expression, or they don't know what you're thinking, or they don't know what you're doing. So they can't, you know, read anything into the mediation process that they should.
That's a really good point. And I have a story that I have to tell, and I'm sorry, because I'm going to take a minute. But I don't know if anybody remembers, a few years ago, there was a YouTube video of a mom sitting in a car at a shopping mall, and she had a Chewbacca mask. And it was a talking Chewbacca mask. And it was the funniest thing I've ever seen in my life. And I was an attorney in a very heated family financial mediation representing my client. My client was in tears and she was upset. So we were looking for funny videos just to kind of lighten the mood. And we found this video, and both of us were laughing so hard we almost peed our pants. And if you're in Wake County, you probably know Caldwell Barefoot, and I'm going to call him out by name because he was our mediator. And he comes stomping into the room, just madder than all heck. I'm trying to be PG here. And he was used like every single word that you could think of. And he was just like, you guys have to be quiet. What are you doing? You're about to blow up this whole thing. They can hear you laughing. They think you're laughing at them. And in reality, we were simply just laughing at this video, trying to get my client to stop crying during the mediation. So that's an interesting point. I love it. Thank you.
I had a mediation recently with an attorney, who I'm not going to name, who was not very professional, was very rude, was not treating me in a respectful way, or anybody at the conference. And the Zoom helped me to fix my face, you know, because I didn't want this person to know that his behavior was bothering me as much as it was. And so I remember looking at my face and giving myself a little admonishment to fix my face, and we were able to move on and get it resolved. But that's an excellent point, Angela.
Okay, so we've got a question in the chat box, which I think is great, is has anybody experienced hacking of any kind on a mediation that they've held?
So I'll just, Tara, I have never had any hacking, because you have to admit folks. They go into the waiting room, and then the host has to admit them into the full meeting. I have had somebody show up that I wasn't expecting. So just as one way of addressing that is I have my scheduler ask the attorneys who will be participating in the mediation, so that I know before the mediation starts, and I have their information, so that I don't send out separate invites to all the participants. I just send the invite to the attorney, but I get a list of the participants. But I did have, there was a possibility that somebody's house insurance could cover something in an employment mediation, which was not really, is not customary. But so that insurance adjuster showed up in the waiting room, and I had to figure out who that person was and why they were coming. But otherwise, I think it's really pretty secure because you've got control over it as the host as to who comes to your mediation. And if you know who those people are going to be, you don't have to worry about that.
And the Zoom has security encryptions that you're talking about, and to prevent that. I haven't had that in any of the mediations I've conducted. However, I do have a middle schooler, and during virtual school, there was a lot of that going on with people hacking in and playing music videos and that sort of thing. But I haven't had any issues with security.
I haven't had any issues.
Yeah, and I see the next question about, do you lock the meetings? I do not, because I have people who go off and come back in, or who they may come in on another computer, or they'll tell me they have to go off. But there is that function on Zoom that you can lock the meeting so that nobody else can come in. But sometimes it can be a little bit like a revolving door with people going to do other business and then coming back. So I don't do that.
Wonderful. All right, David, I've got a question for you. I'm going to put you on the spot. Because because you do in-person and you do remote mediations. In your agreement to mediate, have you included additional language and to put in safety precautions regarding COVID, such as wearing a mask or vaccinations required? Or how do you handle your agreements to mediate? Well, I can't hear you, kid. Hang on. Nope, you're still on mute. Let me see.
I'm not on mute.
Oh, there you go.
Okay. Okay.
Yes.
We modified the agreements slightly, but we also I drafted a separate document that I present in every in-person mediation that I asked the folks to sign that they will comply with the guidelines, specifically straight out of the rule when that went into effect. So we've definitely done that.
Okay. Has anybody else modified your agreements to mediate? And
I send out a notice to them that everybody will be required to wear a mask. I do not ask about vaccination status. I just have decided not to do that, but tell them they'll have to wear a mask and comply with any local executive orders. And then the last one that I actually had the people sign it because compliance was not good at a few of the ones that I did in person, and even with them signing it, it's still, and I am very uncomfortable as a mediator being the police of the mask. So I don't tell people, you need to put your mask on. I just, however it goes, it goes. But I'm always, I want to do whatever I can to protect the participants. But sometimes you just, those folks don't comply, and I just have not tried to enforce it when I've been there and they have not. I'm curious about what other folks have done.
David,
Some of that is very.
Oh, there you go.
Can you hear me okay? Mm-hmm. It seems to me that some of that is so lawyer driven. Some attorneys are just very, very clear about the mask, and they're worn the entire every minute that we're together. Others are looser about it. But Ann's point's a good one. It becomes a challenge to our credibility if we fuss with them too much about that. So it really is a difficult issue to fully enforce. It's just a tough situation, I think.
Okay. So when it comes to enforcing the terms, because I know that when you have people come into your office, how do you deal with the fear of being recorded? So Rule 4E provides that there shall be no recording, but you have really no way to regulate that. So how do you deal with the people and the parties in your mediations to ensure that the proceeding is not being recorded?
Well, one of the things that you can do with regard to Zoom is you can make sure that your settings are set up properly so that no one can record it. And once you get those security precautions in place, if someone tries to do that as the host, it'll pop up and say, so and so is attempting to record, and they're not able to do so as long as you have the settings. I think it would be tricky for someone logistically to be recording it somehow with a phone and have it not be obvious. I haven't had that issue, but I definitely have my settings in Zoom that preclude anyone from recording the proceeding.
And that reminds me, Tara, of a point I wanted to make. So I was on another panel with some mediators, and one mediator told me that the participants wanted to record the mediation for their own use, and they could not understand why they could not, and were trying to be insistent that they have the ability to record the Zoom mediation. And under the rules, of course, you can't do that. You cannot record. The rules specifically address that. So you have to be thoughtful about it. In a live mediation, I see this a lot in employment cases, and I'm sure, Angela, you do as well, where somebody may have a tape recorder in their purse or in their pocket or somewhere, and so they'll use that. I mean, there's nothing you can do about it. If you don't know, you can tell people there's no recording, but then if they do it anyway, I guess the only prohibition is that it's not admissible.
Right, and that's the one of the drawbacks of remote, is that you can't see what everyone is doing, and you can't see what is in the environment that you're in. You have no control over the environment that these people will be in. So I just at the outset of my mediations, I usually will inform the parties that the mediation is not being recorded and it is not to be recorded. And so I've never had anyone to object to that or question that. And if they have recorded it, then it was something that I was not aware of.
I also think, once again, that the lawyers involved on behalf of representing the parties are totally understanding that you can't do that. So the first step is for them to make sure that they have told their clients that. And I don't recall ever having an issue with recording.
Right. That's true. And that's exactly right. I wanted to piggyback on David, because as far as the protocol with regard to COVID and mask wearing and distancing, things of that nature, the attorneys in the cases I've been involved in have really done a good job of making sure that those issues have been complied with, such that I've really never had to address it.
Okay, we've got a great, I'm sorry.
I was just going to respond to something that Ann said before that I totally and unequivocally agree with. The idea of me signing a confidentiality agreement, I'm never going to do it. It's inconsistent with my responsibility under the rules, and I'm just not going to. So I agree with Ann about that.
Yeah, I agree with both of you on that. Good decision. We've got a great question in the chat box, which is, assuming the mediation is court ordered, does the specific ordering courts code protocols govern the mediation? So the way we drafted Rule 4 is we basically said that the mediation shall be remote and follow, the procedure of being remote. And then if all parties agree to be in person, that all safety guidelines need to be followed on a local, state, and federal level. We did that on purpose because we weren't sure how those guidelines were going to move over time. When this all started, we were kind of hoping COVID would be over in a couple months and it would be easy peasy. Few executive orders, no big deal, go back to normal. Clearly, that's not quite the way it happened. So the idea was to create a rule that would basically say you've got to follow the safety guidelines that are in place at the time of the mediation. Now, enforcing it, that becomes the issue, because you're the mediator in the room, and you are there to be a consensus builder and not necessarily walk in and say, you're not following the rules, we're going to have to, do this or that. And so it becomes problematic at best. As far as your agreement to mediate, keep in mind, when you all are designated as a mediator, you can more or less put anything you want in your agreement to mediate as long as the parties are willing to sign it, assuming that you're in compliance with public policy and you're not doing anything illegal within that document. But if you keep it on the up and up, I think that it is completely fair for you to say, as an individual who is being hired by these people, that you're only willing to mediate if they are willing to provide proof of vaccination cards. I think that's okay. Court-ordered mediations are a totally different story. You kind of have to follow the rules on that. So I think that it would be definitely problematic if you were court-ordered to mediate a case and you started making additional requirements on the parties. So if you are concerned about that at all, my recommendation would be to jump off court-appointed lists. So I hope that answers everybody's question. All right, and then we've got a few comments in there. So moving on, and this is going to be a fun one. So scheduling the mediation. And I love to hit on this every single time we do a CME, because this is one of the biggest pitfalls for some reason that people fall into. So what I'd like to ask the panelist is, what is the mediator's responsibility when the parties don't comply with the timeline? How do you handle, especially over the last 18 months, when parties are just refusing to schedule a mediation? Anybody want to jump in? I'll call on someone.
The Socratic method. We'll go back to the Socratic method. Okay. All right. So as we know, Rule 6A1 addresses control. The mediator is in control of the conference from the scheduling date, the time, the location of conducting the conference, to reporting the results to the court. So that puts the responsibility squarely on the shoulders of the mediator in terms of making sure that the conference is scheduled in a timely way. Sometimes I feel like sometimes there's a mediation before the mediation, but you know, in order to get everyone on the same page and work out all the logistics, and you know, seeing some of the comments about different people's experience with virtual mediations. I think some folks have done fewer virtual mediations, others have done hundreds and hundreds. You know, it's sort of creates a whole new spectrum of complexity, but it's according to the rules, the mediator needs to stay on top of it and make sure that these logistics are worked out prior to the mediation.
So when you say that the mediator stays on top of it, just so everybody knows, there are a few different ways that extensions of that mediation deadline can be requested. One is by the parties' consent. So the parties can file their own document and get the extension. The second one is by the mediator. Now, the problem is this takes work by the mediator, but you don't need anybody else to sign off on it. It can be your request alone. So my question to the panelists is, how often, when you needed an extension of time, do you leave it in the attorney's hands, or would you rather just take it upon yourself to file the extension request to make sure that it gets done?
I'll answer that, and then I'll defer to the rest of the panel.
Yeah.
If it's started, I try to work with the parties, and if I know that they're going to do it and they're going to copy me on it, and I know it's been done in a timely manner, I leave it up to them. If that's not the case, I won't let the deadline expire without dealing with it myself. The other two, as we all know, the other two permissible ways to obtain the extension is through judge's discretion or motion and hearing based on one party's request. So it's those four things. I'll defer now.
And Tara, I just defer to the parties. I have a person who just does my scheduling, so she stays on top of it. And it has not really been a problem for me during COVID. I don't know if it has for other folks, but it's actually been actually better than before the pandemic. That I think the parties are working together to make sure that things are held in a timely manner, and there's not as much fussing about it as perhaps there had been pre-pandemic.
In my experience, the attorneys almost always will get an extension by consent. I can't recall a time when I've had to file a request for an extension. So I think the attorneys pretty much feel like that is their responsibility. And as a result of that, it has never really fallen on my shoulders.
So Angela, to follow up on that. Do you have a tracking system? Not that attorneys need to be babysat, but do you have a way to make sure that that document actually gets filed and gets signed?
No, I mean, honestly, I just will rely on the attorneys. Just when they say we'll get the extension, then typically they'll send me an order confirming that they have gotten the extension. Beyond that, I don't have any involvement in the process and no other way of keeping track.
Right.
I think that I've done it both ways. There have been times when we've requested specifically, other times we work with the lawyers and they do it, and I agree with the other folks that it really hasn't been an issue, and everyone has followed through with what they're supposed to do. So it really has not been something that we've struggled with.
Excellent. So just to remind everybody, under 6A1 in the MSC rules, and I believe the FFS rules are the same, is that the mediator is in control of the mediation, and it is the mediator's responsibility to schedule the mediation prior to the deadline. If the ball gets dropped by the attorneys, it is not on the attorneys, folks, it's on the mediator, and the mediator can absolutely be sanctioned by the grievance committee.
So this is one way that this court, there's a rule that a lot of jurisdictions.
Okay, so anyway, make sure that you are getting those mediations done in a timely manner and that the ball is not being dropped, because if the attorneys, even great attorneys, will sometimes not follow through, things happen, COVID hits, everything shuts down, it's pandemonium, but make sure that you are getting that taken care of. All right, I'm going to skip because we're running out of time. Yeah, the extension of time, Kate just put up the rule in the chat box. Check that out. One of the things that I do want to cover, because of course I knew we would not get through all of the stuff that we had, is on your confidentiality. So for confidentiality and motions that are filed with the court, since we're talking about motions to extend, motions to withdraw, how much information do you put on those motions when you file something with the court?
So you have to be very careful because you can't disclose any information that's been communicated to you by the parties that is not, that doesn't have to do with scheduling. So for example, we've all had the situation where one party's been extremely difficult or won't respond, or I've actually had a case where it was a pro se party, but they were, calling me up and yelling at me, and I had to withdraw. So, but you can't say that. I just have said to the court, I have a conflict. I can't continue with this case. And I didn't tell them which side I had the conflict with or what the conflict was. But you have to be very, very careful about what you disclose to the court about any conversations with a party or an attorney, regardless of whether it's from the very minute they're trying to hire you as a mediator, as to whether it's, throughout the course of the mediation.
So a few things that I'm just going to throw out there. These are forbidden comments that the DRC has seen. Don't put plaintiff won't respond. You're requesting continuance because plaintiff won't respond. That doesn't show a good light on the plaintiff in the court's eyes. Defendant canceled multiple scheduled conferences, so we need additional time to mediate. Again, you're throwing the defendant under the bus. You can't do that. I've seen a plaintiff has been difficult to work with and is against the mediation process. Again, the court does not need to know that. That is not for the court. That's something that you call me about, and I will call the party and talk them into the wonderful benefits of mediation. But my favorite is the parties have reached a settlement, but please hold the case open for 90 days for the defendant to pay plaintiff all the funds in full. Clearly, this is way, way, way too much information, folks. Please be super, super simple. One word, need more time, potential for bias. You don't want to put plaintiff, defendant. You don't want any information on any motion that you file with the court. You want to keep it very, very simple. There is one thing that I want to bring up, and I'm going to call on Ann Anderson for this one. And this is partially mediating logistics before the case, because I know you've got a couple good stories with that. But then I also want to talk about good faith. So, Anne,
Okay.
go for it.
So the logistics before the case. So just as a reminder as to specifically, Tara, jump in if I say something that or haven't done address what you're thinking of. But I did have a case where we were going to be in person. I had agreed to do the matter in person, and I was trying to suggest perhaps Zoom. I didn't do that directly, but I just checked in with the parties to see if they still wanted to have the matter in person, because I'd agreed to do it with some of the changes that were going on, and they all said yes. So I said, okay. And then about 30 minutes after that commitment, I got a frantic call from one of the attorneys saying, I just found out that my party is not vaccinated and won't get vaccinated. So I want you to decide that you will have this matter via Zoom, so that it's not on me and the other side won't know that my client's not vaccinated, because it might somehow affect their perception of her. And I kind of struggled with it, but it was, I now knew that somebody wasn't comfortable in having the matter be in person, so I just converted it to Zoom, and I didn't get any pushback from the other side. So that worked out okay. And logistically, I've also had problems with disputes with people turning on their video. So you get into the mediation and one side or the other refuses to turn on the video, and the other side gets upset because the other side hasn't turned on the video. And I've had to mediate that as we get started, because folks will say, if you were in person, I get to see your face. And if we're on Zoom, I ought to be able to see your face too. And the other side says, I don't want to turn on my video. And so, those are some disputes from the beginning. And then, the good faith issue still comes up. People are always accusing the other side of not mediating in good faith, or they'll say in their opening, we're here in good faith to settle the case. And, there is no good faith requirement in North Carolina. There's a business court decision from many, many years ago that has like some dicta about it, but it was specifically determined that was the whole purpose of our rules in North Carolina. They didn't include good faith as a requirement because they didn't want to create any additional causes of action or concerns. They wanted to make mediation as easy as possible. So all a person has to do is show up in North Carolina. They don't have to negotiate in good faith at this point. And so when somebody says that, occasionally I'll address it, but usually I just listen and don't have much discussion with them about it. You can always ask questions like, well, how do you think they're responding to your offer? So you can address it that way. And I see that somebody's asked if one of the participants doesn't have a camera to turn on. I think you're in control of the conference. So if the person doesn't have a camera and they want to participate just by audio or can only participate by audio, I certainly think that's fine. That was not the issue in my case. The people had cameras, they just refused to turn them on, and the few that I've had where that's been a dispute. Did I address everything, Tara?
Yes, you covered it perfectly well. Does anybody else want to comment on the good faith requirement or logistics before the mediation?
The only thing I was going to say with regard to the camera, I agree with what Anne says. Sometimes the vast majority of mine, I've just been giving out gold stars to everyone for coming into Zoom, being able to do it easily. I've offered as a mediator when I send my confirmation letter, if anybody that's participating feels more comfortable practicing logging into the Zoom, I offer that. I've done that a couple times, but at any rate, if when someone doesn't have the technological capacity to turn their video on, then that's just something that I try to address and get consensus as we start the mediation to have a fruitful and productive conference.
Perfect. And we've got a question in the chat box. So the mediation, even though it's required by rule, if the parties contact you directly as a mediator, is that considered court-ordered mediation subject to the statutory fees? So if the mediation is court-ordered, and you are court appointed, then you are bound by the fees set by the Supreme Court in the MSC or FFS rules. If you are designated as a mediator, you can set whatever fee you want. You can put it in your agreement to mediate. So if you think you're worth $1,000 an hour and people will pay it, go for it. And then tell me about it, because that's just amazing. But you have the ability to set your own fees. One of the tricky things is that until the case is court ordered by the judge, it's technically considered a voluntary mediation. Now, many cases will jump the gun and get into mediation before being court ordered. So it is very important for them to use a certified mediator, because eventually the court order will come through. But that is going to be up to the parties themselves to determine that. So hopefully that answers your question. And if you have any additional questions, let me know. There's one thing that I want to bring up real quick before we switch gears. I've had a lot of calls lately about one party who does not want to participate. Okay, and this kind of goes to the good faith issue. You're the mediator, you're in control of the mediation. Once you schedule the mediation, no party can unilaterally cancel that mediation, okay, without consequences. So if you hold the mediation and one party appears and you sit patiently on your Zoom call for 10 minutes and the other party does not appear, then you have technically held the mediation. You just have somebody that is not in compliance of the attendance rule. So you file your report to mediator, you call it an impasse, and you politely hand Rule 5 over to the other side without giving legal advice, and let them know that it is now up to the judge to determine if any consequences should befall the party who failed to show for the mediation. All right. Does any of my panelists have any other questions or comments before we switch gears?
None here.
Nothing for me.
None at all.
No.
And that concludes our first hour of Redefining the Roaring Twenties. We are going to move into a short break. Stay with us for the second hour of Redefining the Roaring Twenties, moving into a decade of technological advancements and what that means for your mediation practice.